On this morning's Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thank you.
Well, let's get to it. We got a lot to discuss, and the first thing we want to look at is the Tax Cuts and Jobs Act, and this specifically looking at estate planning, and as you put it in one of your recent blog articles, it has made it, estate planning that is, much easier for most farm and ranch families, that is, with respect to avoiding federal estate tax. And so let me ask you that, has that been the biggest impact of the TCJA on estate planning for farmers and ranchers?
It's some big impacts of that. The other one that I'll mention here in a second is very difficult to measure, but I suspect it's out there also. But what TCJA did was effectively, in instantaneous, starting in 2018, doubled the basic exclusion amount, meaning the amount of a taxable estate that you could have, or the amount of wealth that you could have and not be subject to federal estate tax. That took it from $5 million to $10 million beginning January 1 of 2018. So for deaths in 2018, you didn't have a federal estate tax problem and had a taxable estate exceeding $10 million. Then that's been inflation adjusted, and it's $12.06 million for this year. And for next year, the 1 year increase in this, Greg, is going to take it to $12,920,000. So, what is it? $860,000 increase in 1 year, which is more than the exemption was itself when I started practicing. It was only $600,000 in total when I first started practicing, and now the 1 year inflation adjustment is going to be $860,000. That's the most ever. So that's the biggest, probably the biggest impact. It eliminates the possibility of federal estate tax for many, many, many people. And when we break it down to farms and ranches, the number of farms and ranches percentage-wise of decedents' estates that are impacted by it is a fraction of 1%. Now, on the flip side, probably, and this is what I hinted at earlier, one we can't measure is I suspect that this causes some people, and I don't know how many, to not do estate planning because they don't think that since they don't have an estate tax problem, they don't need to do estate planning at all. And that's not true. There are a lot of other things that still need to be done, little things, to make sure that your estate passes the way that you want it to, even though you're not concerned about tripping federal estate tax. And I wonder if those things are slipping through the cracks.
Yeah, I was just going to ask, with most farmers and ranchers not really having that estate tax problem at the time of their death, so for those farmers and ranchers, what does estate planning involve for them?
Well, they're associated with this, and this is what it involves for everybody, and that is to make sure that your property passes in the way that you want it to, and so you need a basic will or a trust to accomplish that, or else state law is going to determine who gets your property. And for our farm and ranch families, one of the worst things that can be done if you have multiple children, and particularly some of whom are not interested in farming, but maybe you have one or two that are, you want to make sure that the ones that are interested in continuing the farming or ranching operation into the next generation have the opportunity to do so without interference from their. So the worst things that you could possibly do is just simply leave all the land in co-equal undivided interest to all of the kids. That's going to create problems. And simply not doing anything also is not an option. If you think you're going to let the kids figure it out, most likely you're going to let a judge figure it out. And so some basic things, a basic will, a basic trust, give some thought to where you want your property to go, get it down on paper, powers of attorney for health care as well as financial reasons, and then think about long-term care planning. Do you need some type of, what have you done in terms of planning for potential long-term health care? That's an issue that sneaks up on people perhaps unexpectedly. How are you going to pay for a long-term nursing home bill if that is the case? Do you have long-term care insurance in place? Have you figured out how you're going to self-pay for it? Do you want to make sure that you're protecting the farmland sold, paying to pay for a long-term health care bill? It's those types of things that have nothing to do with imposition of federal estate tax, but those are things that still need to be done. And so those are, I think, Greg, some of the basics that all our farm and ranch families need to think of, as well as everybody else.
What's a little eerie with that is, man, I cannot tell you how many times you have made those points through the programs throughout the years that you keep having to emphasize. I mean, it's not a bad thing to emphasize, but nonetheless, many times you have brought those points up.
Yeah, time and time again. It reminds me of whenever I talk about fences and leases, I've talked about those things and the rules with fences and leases for over 30 years, and the same issues, same questions come up over and over and over again. So it never hurts to continue repeating things.
So let me ask, inflation has affected so many things. What has been the impact of inflation concerning estate planning?
Well, there's two sides on that. One, I mentioned the dramatic increase in the basic exclusion amount, which is going to be almost $13 million next year, and then the present interest annual exclusion goes to $17,000 per donee next year. So I could give away $17,000 up to $17,000 per donee on a cumulative basis, and not have that be subject to gift tax and not even have to file a federal gift tax return. That had been for a number of years. It was $10,000, then it adjusted up. It had been sitting at $15,000 and then $16,000, and now it's going to go to $17,000. So that's one aspect of inflation. It reduces the tax burden that way. Now, the other aspect on inflation, if you've been watching land values, let me just take Iowa land values. That's kind of a measure of farmland values that is commonly looked at. Over the past few years, Iowa land values have in essence doubled in many parts, particularly your good land has doubled. So that the almost $13 million basic account next year is going to come in handy. If I've got 500 acres of Iowa farmland valued at $15,000 an acre, yeah, you do the math on that, you're up there pretty good. And so if I've got a larger farming operation, I'm going to need that $13 million to exclude my estate from federal estate tax, and indeed I might be over it. If I've got a 1,000-acre farm, for example. So that's one impact on inflation. The other impact on inflation is if I have retirement funds, what I have left, not only has the market gone down substantially, the funds that I have left, the dollars that I have left, are now worth a lot less. So you got the twin aspects of inflation, increasing my asset-based values, particularly land, and then putting my investment portfolio and making the cash that I have remaining worth less in terms of its purchasing power. So there are a number of things that have to be balanced on the estate planning and financial planning side of things for farmers and ranchers right now.
Well, like most tax exemptions or things like that, they have an expiration date. So when TCJA is expected to expire in 2026, what do you think we'll see on the level of the estate tax exemption will be that year after TCJA expires?
Boy, I wish I knew. It is going, this annual inflation adjustment is going to end after 25, and when we get to 2026, what the law says right now is that exclusion amount goes to $5 million, adjusted for inflation in 2011 dollars. So it'll probably be about $7 million. So let's say with adjustments in 2024, 2025, so we're going to be basically $13 million in 23, let's say $14 million in 24, $15 million in 25. We would go to a third of that in 2026. So 15 down to $5 million with an inflation adjustment around 7. So in essence, about half That's a game changer for a lot of people. If that happens, and that we just don't know. Now, Congress has never let it drop. It's always gone up, except for 1 year back in 2010, where that was a weird year where you had the option of it being zero that year. But I don't anticipate that's going to happen again. So this is one thing. All we can do as estate planners is take the law as it is, plan for it as it is right now, and as it is, it's going to drop starting in 2026. So we have to have flexible plans in place to make sure that our drafting language and wills and or potential changes to the greatest extent we can in our drafting instrument, potential changes in that basic and there's going to be a whole bunch of estate planning done in the latter half of 2025 as we approach that 2026 change, unless Congress does something. But that's something that we have to keep an eye on.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us. And Roger, of course, this year drought has caused a lot of havoc concerning operations, but specifically if you raise livestock, and of course the extended livestock replacement period does apply in areas of extended drought, and this is concerning the IRS, what they are able to do on the extension of the replacement period under for the livestock sold on accounts there. And what are some of the things specifically to look at for producers out there who are looking at that concerning the tax code to delay, looking at the delayed inclusion of income as well? So how key is that for producers in a year like we've seen this year?
Oh, this is absolutely huge, particularly further west in the state of Kansas and western throughout the plains and west of Kansas and down into Oklahoma and Texas and so forth. So many livestock, and we're talking cattle primarily, excess have had to be sold more than what the producer would normally sell in a given year. Herd liquidation is incredible because of drought this year. And so when you do that, that triggers a bunch of potential income. And there are two tax code provisions that can come into play here. One is a 1-year deferral provision. I don't have to report the income from the sale of the excess number of livestock sold this year. I can defer it to next year. But the big one, I think, for many people, particularly if they're going to stay in the business, is we have an opportunity to defer the reporting of that excess income from the excess head of livestock sold for 4 years if the sale's on account of drought or other weather-related conditions. And there's a rule that's in place that allows the IRS the discretion to extend that 4-year replacement period for an additional year if that particular county where those livestock were at did not have what's known as a drought-free year. And by the end of September every year, IRS is required to produce a list of those counties that qualify a producer for that extended relief. And we got that last week, of course, right up next to the deadline. And when you look at the Kansas counties, it's basically, now it's not 100% accurate to say this, I'm just kind of summarizing. It's basically the entire state except the northeast corner. So if we start up, say, at White Cloud, and you draw a line and you go down through Wabaunsee County, so you pick up Pottawatomie County, Wabaunsee County, and then you kind of curve back and go through Osage and Franklin and Miami County and complete your circle that way. Those counties are not the drought counties. But when you start with Nemaha County and kind of curve around down through Manhattan and Lyon County and Coffee and County, and then everything basically from west of there qualifies for the extended drought relief, the extension of a year. So if you had used this provision in the past and your replacement period would have expired at the end of this year, now it expires at the end of 2023. So it gives you more time to replace those animals and defer the gain on the sale of the excess animals that you had in the past. You can defer it for another year. So each producer needs to talk to their tax professional as to which approach is best for them. And some people may want to report the income this year. Taxes, so to speak, are on sale this year. Taxes are going up. We know that. And it may be okay to go ahead and report some of that gain this year. We just, everybody's situation is different. They each need to talk to their own tax professional. But this is, the IRS has announced this extension, this 1-year extension on the involuntary conversion treatment.
Roger, as we move on, one last topic we want to discuss concerns last week's decision by a federal judge in Iowa. This is concerning a portion of the Iowa, and it's better known as the Ag-Gag laws, but it's a portion of one of those laws that they ruled unconstitutional.
Yeah, this has multiple statutes. The legislature since 2012 has attempted to provide some type of legal protection for livestock animal facilities against those that are intent on doing them harm. And this trespass statute that was at issue here basically was trying to deal with those that would lie on a job application form to get hired, to get access inside a facility where then they could take pictures and videos and then post it on social media and show the world how bad, so to speak, animal agriculture is. That's their business. That's what they do. They are activists that do these things. And so the legislature was trying to say, well, no, if you're trespassing and you're not on the facility legally, and of course lying on a job application is that gets you there under the statute, then you can't do these things, and you can be criminally prosecuted. First offense was misdemeanor, a certain level of misdemeanor, second felony, those types of things. And the court didn't like that. And they basically said, well, that's free speech. You're criminalizing free speech, and you can't do that from a constitution. Now, there are other aspects of the Iowa laws on this that are still constitutional, and this one probably will be appealed. I don't know yet. This opinion just came down last week. But it is very difficult for these livestock operations to protect themselves from this. And many states are struggling to figure out how to do this because these laws have been deemed unconstitutional in numerous states. There's only been a couple of instances where they've been upheld. And, of course, in Kansas, the 10th Circuit said that the Kansas statute was unconstitutional. The other thing I would point out, and I have this in my article, Greg, I think it's very interesting that the judge that issued this opinion last week in Iowa, on that court's website, it says that in order to be admitted into the courthouse, to be in that judge's courtroom, not only do you have to present a government-issued photo ID, you cannot bring a cell phone, a camera, or other electronic device that records anything. Now, isn't that interesting? The judge says, well, if you're an animal facility, you can't do that, but I'm going to prevent you from doing that in my courtroom. I'm trying to connect the dots on that one. I'm having trouble with that. But this is a serious issue for animal agriculture, and we shall see what happens in the appeal on this case if there is one.
It's safe to say this is not going to go away, and for states who have laws like that, they're going to keep being attacked, maybe not the right word, but they're going to keep going back to the courts, one would assume, too. Yeah,
this is not going to end up eventually in the U.S. Supreme Court on this. And on that note, Greg, next Tuesday on the 11th is the oral argument in the California Proposition 12 case. And so I'll be paying close attention to that. Maybe we can talk about that one next time, too.
All right, sounds good. Roger, as always, very much appreciated. And people can go to your blog to get all this information we talked about this morning?
Yes, that's correct. I just learned recently that the email subscription service that was being used, Google canceled that, and so I put a piece on Facebook yesterday suggesting some other RSS services that people can use to get an email notification when I add something to the website or to the blog.
All right, sounds good. Roger, as always, appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law. He has been our guest on the Ag Issues program here on 580 WIBW.